Szanowni Państwo, jako dyrektor Instytutu Wymiaru Sprawiedliwości w Warszawie mam zaszczyt i wielką przyjemność w imieniu całego Instytutu powitać wszystkich Państwa bardzo serdecznie na Międzynarodowej Konferencji Naukowej podsumowującej i jednocześnie kończącej drugą edycję Międzynarodowego Projektu Badawczego pod tytułem Polsko-Węgierska Platforma Badawcza, edycja druga, rok 2022. Witam bardzo serdecznie pana profesora Ede Silagi z Instytutu Prawa Porównawczego imienia Ferenca Madla w Budapeszcie. Panią dr Martę Benusz, panią dyrektor Departamentu Prawa Międzynarodowego i Unii Europejskiej w Instytucie Prawa Porównawczego imienia Ferenca Madla w Budapeszcie. Panią dr Katarzynę Zombory, do niedawna panią dyrektor Akademii Środkowoeuropejskiej Uniwersytetu w Miskolc i naszą dobrą duszę polsko-węgierską. Witam wyjątkowo ciepło wszystkich uczestników, badaczy biorących udział w poszczególnych sekcjach w ramach polsko-węgierskiej Platformy Badawczej, zarówno tych z Węgier, jak i tych z Polski, zarówno tych online, jak i tych na miejscu. Witam w końcu uczestników biernych zgromadzonych tu dzisiaj w Instytucie Wymiaru Sprawiedliwości. Szanowni Państwo, jak wspomniałem na początku, to już druga edycja naszego projektu badawczego o nazwie Polsko-Węgierska Platforma Badawcza. Dziś, po wielu miesiącach przyjemnej, interesującej, ale i ciężkiej i wytężonej pracy badawczej doszliśmy do jej końca. Dziś spróbujemy podsumować pracę poszczególnych zespołów badawczych prowadzących swoje badania w ramach naszej platformy. Międzynarodowy projekt badawczy pod tytułem Polsko-Węgierska Platforma Badawcza w drugiej edycji to badania prowadzone głównie na 4 niezależnych obszarach badawczych. Każdy z tych obszarów był analizowany pod kątem założeń i doświadczenia badaczy z Polski i Węgier. Chcemy, aby ten projekt wespół z jeszcze innymi platformami badawczymi, bo jak Państwo wiecie, Instytut Wymiaru Sprawiedliwości prowadzi jeszcze 3 kolejne platformy badawcze z udziałem badaczy z Europy Centralnej, z takich krajów jak Chorwacja, Słowacja i Ukraina, żeby te wszystkie projekty stały się takimi jednymi z wiodących programów naukowo-badawczych na obszarze szeroko rozumianej Europy Centralnej. No dlatego z wielką przyjemnością zapraszam wszystkich Państwa również na 23 listopada 2022 od godziny 9, gdzie 3 wspomniane platformy polsko-chorwacka, polsko-słowacka, polsko-ukraińska będą prezentowały wyniki swoich badań. Będzie to forma online, link znajduje się na stronie Instytutu Wymiaru Sprawiedliwości. Te wszystkie projekty, sumując, w założeniu mają być polem szerokiej dyskusji, ciekawej wymiany poglądów, nawiązania bliskiej współpracy, mają być kopalnią nowych pomysłów, zdrowych idei wywodzących się z naszego regionu, oddających specyfikę naszego regionu. W tym roku druga edycja Polsko-Węgierskiej Platformy Badawczej to 4 obszary. Wybór ich nie jest przypadkowy, bo każdy z tych obszarów to newralgiczne pole społeczne, ekonomiczne, polityczne, prawne, jakże ważne te wszystkie pola dla przyszłego funkcjonowania naszych wspólnot. Pierwszy obszar badawczy w ramach Polsko-Węgierskiej Platformy Badawczej to prawne aspekty sztucznej inteligencji. Celem naszym było tu zaprojektowanie odpowiednich rozwiązań prawnych w zakresie sztucznej inteligencji, która jest niewątpliwie nowym i jeszcze nie do końca rozpoznanym i nieprzeanalizowanym zjawiskiem, zwłaszcza na obszarze prawniczym. Drugi obszar to reforma sądownictwa administracyjnego. Część druga jest to kontynuacja badań zapoczątkowanego jeszcze w pierwszej edycji naszego projektu rok temu tej problematyki. To analiza, krótko, bo to jest temat bardzo szeroki, dotycząca unowocześnienia i próby zefektywizowania szeroko rozumianych postępowań administracyjnych. Trzeci obszar to ochrona prawna osób starszych. To niebywale ważny, delikatny i trudny do badania obszar. Tutaj w tym miejscu członkowie tej grupy, naszego projektu zmierzyli się ze skomplikowanym, bardzo skomplikowanym problemem prawnym i społecznym, jakim jest niewątpliwie ochrona osób starszych przed aktualnymi zagrożeniami wynikającymi z funkcjonowania w dzisiejszym, dość przecież skomplikowanym społeczeństwie, skomplikowanych relacjach. I w końcu obszar 4 to mediacja. Mediacja w postępowaniach sądowych. Celem było tu przeanalizowanie kwestii alternatywnych możliwości rozwiązania sporu na przykładzie właśnie instytucji mediacji, która, przyznać trzeba tu w Polsce, zwłaszcza dzięki silnemu wsparciu Ministerstwa Sprawiedliwości, ale głównie też dzięki panu ministrowi Marcinowi Romanowskiemu, przeżywa istny renesans. Szanowni Państwo, W ramach polsko-węgierskiej platformy badawczej zgromadziliśmy wybitnych naukowców z Polski i Węgier. Mamy tu przedstawicieli największych polskich i węgierskich ośrodków naukowo-badawczych. Razem to udział 24 badaczy z Polski i Węgier. W ramach projektu tej edycji zorganizowaliśmy kilkadziesiąt comiesięcznych, wielogodzinnych, otwartych dla wszystkich tzw. workshopów naukowych. Przygotowano w grupach badawczych rozdziały do 4 monografii, średnio po 25 stron każdy. To daje w sumie około 250 stron każda książka, a to daje w sumie około 1000 stron analizy we wszystkich 4 książkach. Zorganizowano wydarzenia upowszechniające, poczynając od webinarów po wywiady kończąc. Członkowie poszczególnych grup przygotowywali artykuły naukowe i w końcu zorganizowaliśmy tą dzisiejszą i przypominam, tą jutrzejszą konferencję, które razem wzięte stanowią ponownie, podobnie jak w poprzednim roku, około 14 godzin konferencyjnych razem. Szanowni Państwo, prowadzenie tak skomplikowanego projektu to nie tylko, jak widać, wspaniała intelektualna przygoda, ciekawe badania, rozmowy, analizy, relacje i naukowe przyjaźnie, ale również ciężka praca wielu osób. Pozwólcie Państwo, że teraz wymienię te osoby. Serdeczne podziękowania kieruję w stronę pana profesora Edy Szilagi, pana dyrektora Instytutu Ferenca Madla w Budapeszcie. Chcę bardzo mocno podziękować za dotychczasową współpracę pomiędzy nauką polską a nauką węgierską. I teraz spróbuję to powiedzieć. Szeretném megköszönni lengyel és a magyar eddigi tudományos együttműködését.
Dziękuję bardzo.
Serdeczne podziękowania, już teraz po polsku, kieruję również w stronę pana wiceministra sprawiedliwości, pana doktora Marcina Romanowskiego, za powierzone nam zadanie zorganizowania tych projektów, za ciągłe wsparcie, zrozumienie, przychylność i jak zawsze dobre rady. Dziękuję również mojemu zastępcy, panu profesorowi Pawłowi Sobczykowi, za wielką pomoc, za pomysły, za wszystko, Pawle. Nie obędzie się bez podziękowania również skierowanego do pani dr Katarzyny Zombory za nieocenioną pomoc w organizacji naszych kontaktów i obszarów badawczych. Dziękuję również panu doktorowi Bartłomiejowi Oraziakowi, koordynatorowi Centrum Analiz Strategicznych IWS, za pełne wsparcie, organizację i niezawodność. Dziękuję panu doktorowi Konradowi Burdziakowi za osobiste czuwanie nad przebiegiem projektu, nad organizacją i za nadzór nad przebiegiem projektu. Jednocześnie dziękuję również asystentowi projektu, pani Agacie Wróbel, która wspierała Konrada i samą dyrekcję w prowadzeniu tego naprawdę skomplikowanego, ale bardzo, bardzo przyjemnego projektu. Dziękuję również całemu działowi administracji IWS za wytrwałość w pracy z nami, a także wszystkim pracownikom Centrum Analiz Strategicznych i Wydawnictwa Instytutu Wymiaru Sprawiedliwości za czuwanie, za pomoc. Aga, Marysia, Julka, Asiu, Piotrku, bardzo dziękuję. No cóż, na koniec życzę wszystkim owocnych obrad, ciekawych dyskusji. Serdecznie dziękuję jeszcze raz za udział w projekcie i czekamy niecierpliwie na przedstawienie wyników badań na dzisiejszej i przypominam jutrzejszej konferencji. Serdecznie dziękuję.
Tisztelt igazgató úr,
Szanowny panie dyrektorze,
tisztelt igazgató helyettes úr,
szanowny panie zastępco dyrektora,
dear director and dear deputy director. Tisztelt kollégák, hölgyeim és
szanowni
uraim,
koledzy, szanowni państwo.
először is engedjék meg, hogy
Po pierwsze, proszę mi pozwolić, abym podziękował panu dyrektorowi Instytutu Wymiaru Sprawiedliwości oraz wszystkim kolegom za możliwość, że jestem tutaj osobiście w imieniu Instytutu Ferenca Madla na tym wspaniałym przedsięwzięciu. Jestem za to bardzo wdzięczny. Nie dostałem upoważnienia, natomiast wydaje mi się, że w imieniu pozostałych kolegów, profesorów z Węgier też mogę wyrazić wyrazy wdzięczności, że dostąpiliśmy tego zaszczytu, że w jednej lub w innej formie możemy brać udział w projekcie nadzorowanym, koordynowanym, projekcie badawczym nadzorowanym, koordynowanym przez Instytut Wymiaru Sprawiedliwości. I jednocześnie chciałbym pogratulować całemu dyrektorstwu Instytutu Wymiaru Sprawiedliwości, że już po raz drugi udało się zorganizować tę współpracę badawczą polsko-węgierską i z całą pewnością mogę powiedzieć, że dla węgierskiej nauki jest to niesamowita okazja, żeby na tak brać udział w programie badawczym o tak wysokim poziomie. Gratuluję również, że koledzy z Instytutu Wymiaru Sprawiedliwości oraz pan dyrektor z Instytutu Wymiaru Sprawiedliwości byli w stanie rozwinąć współpracę i rozszerzyć ją na inne kraje. Jako obserwator z zewnątrz mogę powiedzieć, że Instytut Wymiaru Sprawiedliwości bardzo ambitnie rozwija swoje plany na przyszłość i kibicuję im, żeby nie stracili tej siły napędowej oraz żeby mogli rozwijać w przyszłości swoje plany, programy badawcze. Nasza współpraca z Instytutem Wymiaru Sprawiedliwości zaczyna się latem 2022 roku. Nie jest to bardzo długa współpraca, natomiast jest bardzo intensywna. Rok temu również dostąpiłem zaszczytu, aby wyrazić, że Instytut Wymiaru Sprawiedliwości imienia Ferenca Madla na Węgrzech również organizuje, koordynuje i wspiera programy współpracy badawczej, w których biorą udział również instytucje polskie i często za sprawą Instytutu Wymiaru Sprawiedliwości w Polsce. Dlatego chciałbym teraz opowiedzieć o tym, co się wydarzyło w ostatnim roku. Będę się starał nie rozwodzić za bardzo, ponieważ pan dyrektor zaznaczył, że z niecierpliwością oczekuje raportów naukowych, badaczy, pozostałych kolegów, dlatego chciałbym teraz pokrótce podsumować. To akurat przygotowałem w języku angielskim tę prezentację, dlatego myślę, że będzie ona możliwa do przejrzenia dla wszystkich Państwa. To podsumowanie dotyczy lat 2020-2022, natomiast starałem się również zawrzeć w tym nasze plany na 2023 rok. Jeśli chodzi o perspektywę Instytutu Ferenca Madla, właśnie tę perspektywę, z tej perspektywy chciałbym podsumować ostatni rok, który już za nami. Tutaj jest wskazana strona internetowa, na której można obejrzeć nasze programy, ale chciałbym też podkreślić te partnerstwa, dzięki którym mogliśmy osiągnąć wyznaczone cele. CEA Publishing, mówiąc po angielsku, oraz Akademia Środkowoeuropejska oraz jest jeszcze Organizacja Środkowoeuropejska, która również jest naszą instytucją partnerską. Po pierwszej kolejności chciałbym opowiedzieć o wynikach Instytutu Ferenca Madla w latach. Wymieniłem tutaj konferencje zorganizowane w roku 2022. To są wszystko konferencje anglojęzyczne i międzynarodowe. Tutaj praktycznie na każdej z tych konferencji brali udział badacze z Polski.
És közben köszönöm, látom, hogy most már jobban látható lesz a
Widzę, że jest
számára is.
ta prezentacja bardziej widoczna dla pozostałych uczestników. Czyli były tutaj takie konferencje bardziej historyczne, na przykład na temat 800-letniej historii węgierskiej Złotej Bulli, którą przedstawialiśmy na tych międzynarodowych konferencjach. Bardzo ważne jest, że na wyniki tych konferencji byliśmy w stanie opublikować w takich tomach pokonferencyjnych albo w czasopismach pokonferencyjnych. Część już się ukazała w tym roku, część zostanie opublikowana w przyszłym roku. Została już tylko do opublikowania jedna z tych konferencji i spodziewamy się tutaj jej w grudniu. Związana jest ona z ochroną praw dziecka. I Marto Benius, pani dyrektor Marta Benius, która właśnie zajmuje się koordynacją merytoryczną tej konferencji. Wydaje nam się to ważne z punktu widzenia Europy Środkowo-Wschodniej. Ochrona dzieci, ochrona tradycji, dziedzictwa jest bardzo ważna, dlatego cieszymy się, że w tej imprezie Polska jest również reprezentowana na bardzo wysokim szczeblu. Tydzień temu jeszcze wydarzyła się jedna uroczystość, na której świętowaliśmy dziesięciolecie nowego węgierskiego kodeksu karnego, gdzie profesor z Polski również zaszczycił nas swoją obecnością, dlatego polska nauka również była na wysokim szczeblu reprezentowana. I teraz, jeśli chodzi o plany na 2023 rok, tutaj też będą pewne jubileusze. W zasadzie cała nasza koncepcja opiera się na świętowanie różnych jubileuszów. Na przykład będziemy czcić wspomnienie Wiosny Ludów, powstania z 1848 roku, które również wiąże się z historią Polski w osobie generała Józefa Bema, który do dnia dzisiejszego jest świętowany, fetowany na Węgrzech jako bohater narodowy. Jest to bohater narodowy zarówno Polski, jak i Węgier. I tutaj chcielibyśmy upamiętnić to wydarzenie w formie konferencji. Planujemy również konferencje w zakresie praw człowieka oraz wiele innych tematów. Po wszystkich tych konferencjach staramy się wydawać po angielsku tom pokonferencyjny, po to, żeby te wyniki badań były znane nie tylko w Polsce, nie tylko na Węgrzech, ale również na całym świecie. Instytut Ferenca Madla w celu osiągnięcia tych celów międzynarodowych opiera się na wydawcy narodowym. Jest to wydawnictwo środkowoeuropejskie, które już wydało 2 cykle wydawnicze. To są obwieszczenia Instytutu Ferenca Madla. Już wydaliśmy tutaj 1 tom w języku angielskim, który przywieźliśmy ze sobą na konferencję. Mamy nadzieję, że zostanie tutaj to przyjęte ciepło w Polsce. Tutaj występuje również w tej publikacji Polska i myślę, że w osobie Katarzyny Zombori była w stanie zaprezentować tutejsze ustawodawstwo dla węgierskiego czytelnika. Jeśli chodzi o Legal Heritage, to jest to taki cykl wydawniczy oparty na dziedzictwie, na historii i właśnie z okazji tego jubileuszu Złotej Bulli węgierskiej staramy się zaprezentować prawodawstwo węgierskie oraz w związku z innymi jubileuszami fetowanymi na Węgrzech mamy nadzieję, że zachęcimy do tego polskich kolegów, do właśnie organizowania różnych wydawnictw, konferencji w związku z różnymi jubileuszami. Kolejny cykl wydawniczy to jest Życie i dzieła Ferenca Madla, to jest, prawda, były prezydent Republiki Węgierskiej. Wspominaliśmy właśnie 90. rocznicę jego urodzin oraz 10. rocznicę jego śmierci i w związku z tym mamy nadzieję zorganizować konferencję anglojęzyczną. Oprócz tego Instytut Ferenca Madla współdziała w różnych innych projektach, na przykład we współpracy z Akademią Środkowoeuropejską. I tutaj chciałbym zwrócić uwagę na 2 programy tej akademii. Pierwsza to jest sieć profesorów z Europy Środkowo-Wschodniej, w której uczestniczy również bardzo wielu profesorów z Polski. W 2022 roku tematy były dosyć podobne jak w tej polsko-węgierskiej platformie badawczej, czyli na przykład prawodawstwo regionalne. Wszystko to są takie tematy, które są ważne z punktu widzenia prawodawstwa środkowoeuropejskiego, po to, żeby te cechy charakterystyczne tego regionu wyrazić w prawie, w nauce o prawie, żeby nie patrzeć tylko z punktu widzenia jakiejś mody prawniczej naszego ustawodawstwa, ale spojrzeć na to z punktu widzenia naszych narodowych właściwości, tworząc taką własną szkołę, żeby badać to właśnie z punktu widzenia naszej regionalnej szkoły. W zeszłym roku to powstało. To nie jest taka inicjatywa przeciwko czemuś, to jest inicjatywa pozytywna. Po pierwsze, ochrona prawa do życia w erze cyfrowej oraz nadzór rodzicielski. Dlatego wymieniłem to, ponieważ tutaj dyrektor Instytutu Wymiaru Sprawiedliwości koordynuje te dwa tematy. Te książki, te tomy pokonferencyjne również zostaną wydane w tym wydawnictwie, które już wspominałem, wydawnictwie środkowoeuropejskim. Natomiast artykuły fachowe publikowane są w dwóch czasopismach. Jest to Central European Professors Network. Wszystko się odbywa w języku angielskim. Law, Identity i Values to jest drugie czasopismo, czyli dziedzictwo i wartości. Tutaj są widoczne te tomy pokonferencyjne po konferencjach z 2021 roku. Te też możemy Państwu zaprezentować. Miejmy nadzieję, że w przyszłym roku będę mógł pokazać tomy wydane w tym roku. Kolejny program Akademii Środkowoeuropejskiej dotyczy młodych ludzi i zapewnia współpracę w 4 obszarach pomiędzy Polską, Słowacją, Czechami, Rumunią, Chorwacją, Serbią i Węgrami w zakresie nauki o prawie na poziomie studentów, doktorantów oraz nie są to tylko Węgrzy, ale są również różne mniejszości narodowe. Profesorowie z całego regionu zarządzają pracą młodych badaczy, a jeśli chodzi o materiał do nauki, on również jest dobierany z prac profesorów regionalnych. Ten program działa od 2 lat, dlatego jest bardzo otwarty na współpracę z polskimi uczelniami, z polskimi placówkami badawczymi. Wydawnictwa tego programu również są wydawane przez wydawnictwo środkowoeuropejskie. I są różne inne ciekawości związane z tym programem. Pierwsza jest taka, że w tym roku rozpoczęliśmy już przygotowania do stworzenia czasopisma fachowego zarządzanego czy tworzonego przez studentów. Nasi słuchacze, ta młodzież z tego regionu z dużą radością przystąpili do tworzenia tej publikacji, tego czasopisma naukowego i są bardzo wygłodniali sukcesu. Dlatego chcieliby, aby czasopismo było sukcesem. Kolejna inicjatywa, która już w tym roku została urzeczywistniona, to jest duża konferencja międzynarodowa, która odbyła się pod nazwą SESJA. I cieszymy się bardzo, że w Europie Środkowo-Wschodniej, wliczając tutaj Polskę, bardzo dużo młodych badaczy wzięło udział w tym przedsięwzięciu. Dla młodych badaczy jest to inicjatywa dedykowana. Nie zapominajmy o tym, że przyszłość naszych narodów opiera się na pracy badawczej młodych naukowców. Bez nich nie uda się utrwalić dziedzictwa kulturowego, dziedzictwa prawniczego. Mamy ogromną potrzebę właśnie wspierania tych młodych badaczy. I teraz widać 4 książki, które ukazały się w ramach tego cyklu wydawniczego. I tutaj mogę powiedzieć, że 5. też się ukaże, redagowana przeze mnie, więc zapewniam Państwa. I w tym roku kolejne 5 zostanie wydane w tym cyklu. Tutaj to są stażyści, doktoranci. Dla nich to są jakby materiały obowiązkowe, ale miejmy nadzieję, że będą one ciekawe również dla innych środkowoeuropejskich placówek badawczych oraz pojawią się tacy młodzi badacze, którzy będą zainteresowani prawem krajów tego regionu. Zauważyliśmy taki brak, że bardzo mało jest anglojęzycznych materiałów dotyczących prawa regionu naszych krajów. I na sam koniec chciałbym zwrócić uwagę na współpracę z Organizacją Środkowoeuropejską. Tutaj wystartowaliśmy z 2 ważnymi programami. Pierwsze to jest ocena badań, czyli ocena wydawnictw badawczych. Tutaj odbyliśmy konferencję w styczniu 2022 roku. Bardzo ważne jest, żeby stworzyć fora badawcze przydatne właśnie do nauki o prawie i tutaj w tych ramach mogę powiedzieć, że kwalifikacja, klasyfikacja, metodologia oceny opracowana w Polsce jest bardzo ważna. Drugi program, który chciałbym tutaj wymienić, to znowu jest platforma dla młodych. I właśnie na konferencji w październiku 2022 roku został wystartowany ten program, w ramach którego stworzono platformę do współpracy dla młodych badaczy. I chciałbym podkreślić, że bardzo liczymy na Polskę i na polskich badaczy, zarówno na starsze pokolenia, na te bardziej doświadczone, jak i na młodzież zajmującą się badaniami. Myślę, że wspólnie możemy osiągnąć doskonałe rezultaty. I bardzo dziękuję za uwagę Państwu i jeszcze raz dziękuję, że otrzymałem możliwość od Instytutu Wymiaru Sprawiedliwości, żeby być obecnym na tej konferencji. Bardzo dziękuję.
Szanowni Państwo, to jesteśmy po oficjalnej części naszej konferencji. Teraz krótka przerwa techniczna i rusza pierwszy zespół dotyczący, jeśli dobrze pamiętam, i patrzę na agendę tak troszeczkę dalej, sztucznej inteligencji, choć pan profesor Sobczyk już mi tutaj podpowiada, że tak, mam rację, czyli za chwileczkę ruszymy z prezentacją wyników badań zespołu poświęconemu zagadnieniu sztucznej inteligencji.
Ladies and gentlemen, my name is Agnieszka Greszczyńska. I am a professor at the Faculty of Law and Administration of Cardinal Stefan Wyszyński University in Warsaw. Moreover, I am a prosecutor in the National Prosecutor's Office in Poland. I wish to warmly welcome you to the Polish-Hungarian Research Platform Conference in the panel on artificial intelligence. Artificial intelligence is a fast-evolving family of technologies that can bring a wide array of economic and societal benefits. By improving prediction, optimizing operational and resource allocation, and personalizing service delivery, artificial intelligence can support socially and environmentally beneficial outcomes. Growth in computing power, availability of data, and progress in algorithms have turned artificial intelligence into one of the most strategic technologies of the 21st century. Artificial intelligence applications can provide a competitive advantage, but may also imply new risks or adverse consequences felt by individuals and society. In the area of justice, artificial intelligence, if it's based on trust, can lead not only to a reduction in costs, but also to a significant reduction in the length of the trial or the delivery of a verdict. The lack of the legal framework for artificial intelligence in both Poland and the European Union leaves us in a legal uncertainty. There is still a long way to go until the draft Artificial Intelligence Act is finally approved and made binding on member states, but it already represents a step forward, and also in terms of the possibility of using AI in the administration of justice. The way we approach artificial intelligence will define the world we live in. The fundamental questions to be asked, however, concerns the method, scope, and level of legal regulation of artificial intelligence. Answers to these questions can help verify the research hypothesis of whether trustworthy, ethical, and human-centric artificial intelligence can support law enforcement and the administration of justice, contributing to a better fulfillment of the right to a fair trial. Leaving you with these questions, I invite you to the presentation prepared by members of the team analyzing selected regulatory challenges posed by artificial intelligence. I would also like to point out that the entire study, along with the final conclusions, will be presented in a monograph. We have 6 members of legal aspects of artificial intelligence team presenting their papers at today's conference. At today's conference, the first lecture will be given by Professor Istvan Ambrus, who is an associate professor of criminal law at the Eötvös Loránd University in Budapest. Dear Professor, I would like to invite you to present a speech entitled Something Old, Something New, How to Establish Criminal Liability if the Offender is AI itself. So, Professor, the floor is yours.
Ladies and gentlemen, dear colleagues, first of all, I'd like to say that it's a great honor for me to be a member of this research group between Poland and Hungary related to the artificial intelligence phenomenon. And as a criminal lawyer, in the next about 20 minutes, I'd like to share with you some of the conclusions of my previous researches related especially to the substantive criminal law point of view related to artificial intelligence. And firstly, my opinion related to these matters is that from a point of view of the substantive criminal law, it's going to be a quite great challenge and a quite hard task to establish the criminal responsibility related to the artificial intelligence, especially if we are talking about, for example, in the field of traffic law, the so-called self-driving cars or autonomous vehicles. So the question will arise, if the artificial intelligence itself will cause harm, who can we blame for this harm, even, for example, for a fatal accident in the traffic caused by the self-driving car itself. Okay, first of all, several articles dealing and trying to somehow define and codify the artificial intelligence phenomenon itself. No, my aim won't be to deal with the definition in detail itself. I only like to cite possible definition by the European Commission from 2018 and to share with you some general features and conditions related to the artificial intelligence. However, of course, as the most recent developments, you can see on the slide the newest achievements cited and stated by the European approach, by the European Union. So the general features which should be mentioned related to artificial intelligence is to make a distinction between the autonomous and the automatic using of these tools, and we should state that in the case of the artificial intelligence, it should be always an autonomous one, which will another interesting issue, but I won't talk about this in the lack of time, how to make a distinction between the so-called weak and strong artificial intelligence. Of course, it's usually related to the so-called deep learning technology, while these autonomous tools and artificial intelligence run agents there will be a so-called unpredictable outcome, especially as we will see in the field of the self-driving cars. And sometimes the question also arises if should the artificial intelligence be so-called humanoid one. Of course, it's not an essential feature. It could be, but for example, in the field of the industry or the medical tools, of course, those tools aren't humanoid ones. And you can see here the possible fields where artificial intelligence can be used. However, from an approach of a substantive criminal lawyer, probably the problems of the self-driving cars will be the most interesting and also most problematic. Just briefly, the so-called philosophical background related to the artificial intelligence, you can see an opinion from Descartes and also from Professor Dreyfus. They both of them agreed that the machines, the robots, cannot express their thoughts, thus we cannot establish the criminal liability. We cannot blame the artificial intelligence phenomenon itself in the case of for example, a traffic accident. Okay, now you can see the framework of the possible legal responsibility from the most important branches of the law. Of course, as a criminal lawyer, I will deal with the substantive criminal law matters, although I probably should mention that in the field of the civil law, which Professor Veres is going to talk about, there could be probably those kind of liability models which are so-called strict and objective kind of liability models. Thus, we can somehow blame somebody, of course, because of the accident, for example, caused by the artificial intelligence. However, if talking about the substantive criminal law, as we can see later, the previously, especially since the 19th century, when the first Hungarian criminal code, usually called the Csemegi Code, was elaborated in 1878, the goal of the substantive criminal law was to punish a natural person, of course, who actually committed his or her offense with personal guilt. And of course, there wasn't any obstacle to establish the criminal liability, like, for example, minority or insanity or a mistake. Originally, the aim of the criminal law was to punish natural persons, Thus, it's quite weird if we would like to establish criminal liability in a case of a robot, like an artificial intelligence, for example. Just to cite an interesting opinion from Laszlo Vizsky in the field of the traffic law, he stated back in 1974 that the foundation for the safety of traffic will be at least 4 generations up to the personal performance of the driver. However, if we are considering an artificial intelligence run self-driving car, possibly we should somehow amend this before mentioned opinion by Vizsky. Okay, let's check what kind of questions will arise if we are talking about the liability related to the artificial intelligence phenomenon. First of all, who can be the offender of the, it's an abbreviation, it's quite widespread in the Anglo-Saxon literature, the AIC, which is the artificial intelligence crime, of course. There could be models dealing with criminal liability, also the obstacles of criminal liability, the criminal offenses, which could be the liability established for from the special part of the criminal code, and finally, what kind of sanctions can we impose if, for example, the artificial intelligence will cause harm. I actually showed you previously this slide. So as a main rule, previously, we always needed a natural person, so a human being, who fulfilled the statutory elements of a concrete criminal offense, and he or she was personally guilty. Then, of course, there could be a prosecution, and finally, a sanction can be imposed as a main rule by the criminal court. However, if there's no human conduct at all in the concrete case, then the question is still opened. Who can be blamed in this situation? Okay, first of all, of course, we should try to decide if the artificial intelligence itself could be liable for the criminal offense or not. Of course, if we are talking about and dealing with the classical dogmatical issues, which states that there should be always a conduct which should fulfill the statutory elements of a criminal offense, it should be unlawful, and finally, the personal guilt of the perpetrator is needed, then we can state that even the first condition won't come about in the case of the artificial intelligence, because as a main rule, it should be a human conduct. Of course, the human can use a tool or even an animal, for example, to commit the criminal offense, but a human conduct is needed if we would like to establish criminal liability, and it should, of course, appear in the outside world, and it should voluntary. Thus, if we're considering to establish the criminal liability of the artificial intelligence itself, we should somehow reduce this before mentioned definition, because the lack of the human conduct and also the lack of the voluntariness of this conduct. You can see 2 other negative opinions by John Locke and Immanuel Kant. They both stated previously that only a human being can be conscious and can understand the aims of the punishment. This is the main opinion, of course, of Kant, dealing with the doctrine of indeterminism. And thus, of course, a robot or a machine cannot punish related to this opinion. However, we should mention the opinion of Professor Weigand and his co-authors from 2016. They also stated that at least nowadays, the artificial intelligence cannot be punished. However, probably in the future, especially if the strong AI will be possible to come about in a technological sense, then this could be probably changed in the future, but right now we cannot blame the artificial intelligence itself. If we cannot, then we should seek for the human being who can be blamed for the, for example, the fatal accident caused by the artificial intelligence. In the Anglo-Saxon literature, it's usually called the man behind the machine doctrine, when we are seeking the person, the natural person who can be blamed for example, the accident. It could be, for example, the user of the self-driving car. Actually, in the United States, there was already a case where a fatal accident happened, and the user of this self-driving car had the duty to monitor what's happening during the road. However, he didn't. Instead, if I remember correctly, he read the newspaper, for example, during the road, and then this fatal accident happened. Then, is this user, or can we consider this user as a driver? At least in the Hungarian criminal law, we cannot. Because we have in the traffic law, in the chapter dealing with the traffic offenses, in the special part of the Hungarian criminal code, these criminal offenses are so-called blanket laws. The blanket law, which is actually fulfilled by another act, which is with the Hungarian abbreviation, is the KRESZ, and there's a definition for the driver in the KRESZ, and this driver is who actually driving the car, and not that person who just sit in the vehicle and, for example, reading a newspaper. So at least recently, we cannot establish the criminal liability. However, if not the user, probably the programmer can be blamed. For example, if he or she, by negligence, committed a criminal offense related to the technological matters of the artificial intelligence. And finally, probably we should observe the possibility to make liable the owner of the AI. However, this is a highly debatable opinion, especially if we take into consideration that the owner could be even a legal person, and the possibility to punish legal persons, it actually exists in the Hungarian criminal law, but despite the fact that this act is in force for almost 20 years in the Hungarian criminal law, since Hungary joined the European Union back in 2004, it's quite really strange for the criminal lawyers to punish legal persons and call this a criminal punishment. However, this is in force, and as backing close to the end of the presentation, I can share with you that our opinion is that if there still will be a need to punish somebody if the artificial intelligence cause a harm, we should somehow make a legislation similar to the responsibility of the legal persons also in the criminal matters. However, as you can see, there are several problems with this opinion also. There could be a so-called manufacturer's liability, which is actually a private law-like strict liability and kind of objective liability, which is still strange considering the continental criminal laws, just like the Hungarian one. However, as you can see, there are more examples nowadays in the Hungarian criminal code, which actually makes liable not the person actually who fulfilled the statutory elements of the concrete criminal offense, but another person instead. And there are those models, like an indirect perpetrator, or for example, if a commander gives an order to the soldier, and this soldier will commit the criminal offense, but he or she isn't aware about that the order finally leads to a criminal offense, then the commander will be liable instead of the soldier. So there could be some kind of models, but those are always just not the main rule actually in the criminal law, which I already stated that the aim of the dogmatical and continental criminal law is to punish those human beings who committed the criminal offense their own. Okay, there should be, or we should talk about the obstacles of criminal liability also. In the lack of time, I won't deal with those, of course, in detail. Just mention one. There was an interesting article in the Anglo-Saxon literature with the title, Google Made Me Do It. Because in the concrete case, the charged person tried to protect himself in the criminal proceedings with saying that the Google Maps told me on my smartphone to choose this road, and that's why the accident came about. Thus, finally, I'm not liable. Let's punish the Google instead of me. The criminal offenses, which cannot be, of course, discussed. It could be a separated lecture, of course. However, I already mentioned the traffic offenses, but there are several other chapters in the recent Hungarian criminal code where the responsibility related to the artificial intelligence can come about, just like cybercrime, so offenses against information systems, or even offenses against property, just like a regular fraud or for example, an information system fraud, or even economic crimes. Okay, and finally, our opinion about the sanctions. Of course, if there's a possibility to punish a human being related to the accident, for example, caused by the artificial intelligence, of course, the regular penalties and measures which are regulated in the criminal code can be imposed. However, dealing with the possible liability of the artificial intelligence, there could be similar sanctions to the sanctions which can be imposed in the case of the legal persons, just like the limitation, a fine, or even a confiscation, for example. And finally, as far as my time is over, I'd like to thank you very much for your attention and have a great conference together.
Thank you very much for your presentation. Time for discussion is scheduled after the presentations in this panel. So now I would like to move to my presentation entitled The Impact of AI on Cybercrime. Will it facilitate the actions of perpetrators or enhance the effectiveness of law enforcement? Okay. Can I have my presentation on this screen also? As a preliminary point, it's worth noting that the development of application and deployment of artificial intelligence in various fields can cause both benefits and harm. The white paper, Artificial Intelligence, a European Approach to Excellence and Trust, outlined strategic options for regulatory actions to enable the development of AI that can benefit citizens, business, and society as a whole, provided that AI is human-centered, ethical, sustainable, and respect fundamental rights and values. At the same time, the white paper points out the risk associated with cybersecurity, AI application in critical infrastructure, or malicious use of AI. The aim of my presentation is to analyze the impact of AI on cybercrime. So going forward, AI and its application, for instance, automated decision-making, especially in safety critical developments such as in autonomous vehicle, smart manufacturing, e-health, may expose individual and organization to new and sometimes unpredictable risks, and it may open new paths in attacks methods and techniques, as well as creating new data protection challenges. The use of AI for cyber attack detection, analysis of large sets of personal and non-personal data, profiling or stilometry can benefit cybersecurity, though faster detection of an attack, its attribution, collection of analysis of the data necessary to hold a specific individual criminal responsibility. Artificial intelligence can also benefit cybercriminals by automating their attacks and adapting their scenarios to an established profile of the victim. So when considering cybercrime in the context of AI, it is important to consider the following. Artificial intelligence can be used in classical attacks as a means, as a tool of augment cybercrime and facilitate attacks by malicious adversaries, such as using, for example, deepfake to impersonate another person in a SEO fraud attack. But artificial intelligence can be a key target for an attack. If we are simplifying by assuming that AI is a collection of technologies that combine data, algorithms, and computer power, we will understand what needs to be secured, what assets that are subject to AI-specific threats and adversarial models. Also, AI can be used to enhance cybersecurity. For example, traffic filtering, counter cybercrime, for example, automated forensic analysis, or ensure the right to a fair trial. So if we are discussing cyber threats, as the European Union Agency for Cybersecurity, ENISA, points out, artificial intelligence and cybersecurity have a multi-dimensional relationship and a series of interdependencies. The dimensions that may be identified include the following three: cybersecurity for AI to support cybersecurity, and of course the malicious use of AI. As adversarial use of an AI can create more sophisticated types of attacks. For example, deep generative models to create fake data, AI-supported password cracking. Moreover, ENISA has prepared AI threat taxonomy description, including potential impact and affected assets. So we should go through AI threat landscape, and what can we see here? If we are talking about the present state of malicious uses and abuses of AI, we should think about AI malware, abusing AI cloud services, abusing smart assistants, AI-supported password guessing, AI-supported CAPTCHA breaking, and AI-aided encryption. Also, we can see some trends that can be found on underground forums. For example, human impersonation on the social network platforms, online game cheats, especially for games where monetization is substantial, AI-supported hacking, Several discussions on underground forums provide additional insights on the practical use of frameworks such as deep hack and the deep exploit. AI-enabled password guessing tools are also already in use in hackers and other criminals. As AI technology develops, so the different schemes for social engineering that might profit from such technology. This is crucial to note, as Europol has noted in 2020 that social engineering still serves a top threat that is utilized for facilitating other forms of cyber crime. In evidence of this scheme, several interesting discussions related to AI-enabled tools to improve social engineering tasks have been found on different underground forums. And of course, we can also think about future scenarios of malicious users and abuses of AI, such as, for example, content generation, content parsing, or even AI-supported ransomware. Since I have limited time for my presentation, I would like to show only two examples of attack. The first is attack where AI is a target, that is attacks on self-driving cars. The second example is deepfake, where algorithms are used for both monetization-oriented attacks, for example, impersonation during identity video verification, as well as disinformation, for which mostly state actors are responsible. So going to the first one, in autonomous driving, for example, the algorithm uses in real time the data from the car, like speed, engine consumption, and from the sensors scanning the whole environment of the car, like road, signs, other vehicles, pedestrians, to derive which direction, acceleration, and speed the car should take to reach a certain destination. Based on the data observed, the algorithm adapts to the situation on the road and to the outside conditions, including other drivers' behavior, to derive the most comfortable and safest drive. Since the inception of autonomous vehicles drive tests, there have been various types of attacks on different units of a self-driving car, such as the internal measurement unit, LiDAR, GPS camera, and so on. So there were approximately more than 120 incidents reported so far till 2020. So those attacks really exist, are possible. Various threats associated with the different scenarios, controls, and connections mechanisms have been identified. In addition to the vulnerabilities specific to machine learning systems and AI-related security issues are taking advantage of the more classical hardware and software vulnerabilities presented in digital systems, extending standard attack vectors. More precisely, some of these security issues and vulnerabilities usually mentioned include, for example, sensor jamming, denial of service attacks, manipulation vehicle communications, or informational disclosure. Another example, and one of the most visible malicious uses of AI, is the phenomenon of so-called deepfakes. Deepfakes involve the use of AI techniques to manipulate or generate visual and audio content that is difficult for humans or even a technological solution to immediately distinguish from automatic ones. So this technology can be a powerful weapon in today's disinformation wars. One can no longer rely on what we can see, moreover, coupled with the reach and speed of the internet, social media, and messaging application, deepfakes can quickly reach millions of people in an extremely short period of time. With regard to such a short time frame, deepfakes present considerable potential for a range of malicious and criminal purposes, which includes destroying the image of or a credibility of the individual, or, for example, distributing disinformation, falsifying or manipulating electronic evidence, and even disrupting financial markets. Deepfakes are created by manipulating content to produce a synthetic audiovisual file and make it appear genuine. Although examples of this malicious abuse of deepfakes, such as the aforementioned, have been witnessed, the deepfakes creation technology is not being employed on a large scale by criminals yet. That is really interesting. The main use of deepfakes still predominantly appears to be for non-consensual pornographical purposes. Current criminals' tools, techniques, and approaches are likely to be more effective and easier to employ. They would also be less costly and less time-consuming. So this technology is not often used by cyber criminals. Let's start with a question. What do the people shown below have in common? None of these people exists. Fake face generators can be used in many ways, and creating a fictional character is becoming easier than ever. All the images shown above come from a face generator. Each time the site is refreshing, it generates a new face created using machine learning algorithm. The system analyzes thousands of photos and of real people, and so I can see a real problem. Realistic images of deepfakes can be used for sorts of scams and frauds, or at best to, for example, credibility of online accounts aimed at trolling or scamming. So it can be a serious problem. And I was searching for some information about the use of the generated pictures, and the AI image generating craze has entered its next phase to absurdity, creating fake profile pictures that make you look good on dating apps, in social media even. But we have to also think how AI can be used for detect cyber attacks and identify their perpetrators. First question, machine learning algorithms can be used to recognize misleading content and web domains impersonating logging panels for known services like email or banking accounts. According to the report prepared by CSIRT-NASK in 2021, perpetrators attacking in Poland most often impersonated Facebook. According to Orange Polska analysis, it is extremely difficult to protect a victim from accessing the website impersonating another entity, because malicious domains are usually registered on the day of the attack is carried out, and 80% of attempts to enter a malicious website occur within 15 minutes from the moment the victim received a SMS message with a link. So those data are really interesting, but what is also interesting, fake websites for generated socio-technical attacks use certificates. So, therefore, in the detection of malicious domain, real-time analysis of streamed data can be helpful. CertStream is an intelligence feed that gives you a real-time updates from that certificate transparency log network, allowing you to use as a building blocks to make tools that react to a new certificates being used in real time. So this is an example of how the CertStream looks like. And in Poland, phishing websites can be blocked by telecom operators after they have been added to so-called warning list, which contains a list of websites that pose a threat. Also, the regulatory proposals are designed to counter such electronic communication abuses in artificial traffic generation, smishing, or caller ID spoofing. Although the catalog of electronic communication abuses is not closed, measures such as monitoring of electronic communications are introduction of smishing messages patterns, the creation of a list of internet domains that are used to phish internet users' data and frauds, or a list of numbers used only to receive voice calls are assumed. The use of machine learning algorithms to detect malicious domain sent in electronic communication and block them may be necessary due to the extremely short time for analysis and reaction. AI can also be used to detect cyber attacks and identify their perpetrators. The potential of using AI is particularly in the analysis of both structured and unstructured data. Very interesting is also using stilometry and machine learning to identify criminals. It is obvious that the vocabulary we use can be characteristic for us, just as programming style can be characteristics. So stilometry can be used both to study posts on dark web forums or internet conversation. It can also be used to determine the author of the malware code or an example. AI can also be used to ensure the right to a fair trial. The right to a defense proposes the ability to receive the evidence gathered in the case, whether and how is this right realized in the case that has more than 100 or 1,000 volumes. How to ensure access to the file for the party and its or her attorneys in multi-volume cases and enable them to prepare their defense. It's a very important question. The right to a defense presupposes the ability to receive the evidence gathered in the case. What if there are dozens of people in such a case who want to exercise their right to see a file at the same time? I go too far. I'm just finishing because my time says finish also. The process of the digitalization of preparatory proceedings files in Poland has been ongoing since 2013. And the aim of the project was to implement a system of digitalization of preparatory proceedings file to create local systems in common organizational units of the Public Prosecutor's Office for collecting, processing, and making digitized files available. So another application is to use machine learning and AI mechanisms to anonymize those data. Digitalization of files leads to creation of a databases that can be used to teach algorithms that would then support the decision-making process and automatically generate drafts or selected letters, files, documents. In criminal proceedings, in connection with the occurrence of a specific state of facts, specific actions are taken as indicated generally applicable law. But standard letters are prepared or specific decisions and orders are issued. Some of these actions could be subject to algorithmization and automatization, and a learning algorithm could prepare ready-made draft, only a draft, not a decision, a draft for a procedural decision subject to approval by the prosecutor on the basis of legal regulation, and it's quite, let's say, useful and also available, technologically available. So to conclude, artificial intelligence can be used by cyber criminals, automating their attacks and adopting their scenarios to establish profile of a victim. But application of AI to analyzing large sets of personal and non-personal data, profiling, stilometry, cyber attack detection can benefit cybersecurity, though faster detection of an attack, its attribution, collection of analysis of data necessary to hold a specific person criminally responsible. It can also facilitate the de-anonymization of perpetrators, establishing their identities, and thus have a positive impact on the fight against cybercrime. The use of AI to detecting and combining proceedings for the same crime, analyzing files of digitalized cases to establish links and dependencies in identical modi operandi can improve the effectiveness and efficiency and effectiveness of pretrial investigation. So thank you for your kind attention, and having this privilege, I will also ask the next presenter. Here we have a little change in the program, as Professor Barnabas Hayas is online. His presentation will be at the end of our session. And now I would like to invite Professor Emond Veres, who is a professor of private law in Miskolc in Hungary and Cluj in Romania. Currently, he's also head of the private law department of Ferenc Madl Institute of Comparative Law, for the presentation AI from the perspective of civil law, a person or a liable person. So we go to the civil regulation. Now, thank you very much for your kind attention. The floor is yours.
Thank you very much. And indeed, we will move to the civil law questions of AI. And dear colleagues and conference participants, it's a privilege to be here and present some of the research results from the point of view of private law. And I would like to outline the main conclusions of my research during our collaboration with the excellent research team in the past few months, practically to show some regulatory proposals which must naturally stem for these results. Firstly, the interrelations of the two major issues raised by the development and already ongoing implementation of AI systems should be identified. Liability for damage caused by artificial intelligence and the proposed solutions to address such situations, among them granting legal personality to AI entities as strongly connected with liability gaps posed by artificial intelligence in the present. Secondly, I would like to discuss in some details these liability gaps and in the particular situations in which the standard presently in force civil law rules, liability rules are break down and seems to not functional, at least fully functional. Thirdly, the potential also negative effects of granting legal personhood to AI as a solution to those liability gaps as it is proposed by somebody. Fourthly, I shall analyze the solution proposed by the EU legislator to these problems as it seems to emerge from the proposed Artificial Intelligence Act and Artificial Intelligence Liability Draft Directive and in their preparatory instruments. And finally, I shall address some regulatory proposals for the future legislator which will deal with the problems of AI. Let's start with the interrelations of AI personhood and AI damage. And as we had to observe during our research, AI is a completely novel technology based on several solutions. Chief among them are those collectively known as machine learning, usually implemented on some type of artificial neural network, which are capable of automatically discovering and harnessing relationships in datasets provided by human or even discovered by the AI themselves. Therefore, unlike other important technologies such machines or computers or telecom systems, which are used under strict human supervision, AI is different because it is capable of behaving in an unpredictable way, not just as a result of unintended but predictable factors, but also as a result of unpredictable factors, such known unknowns, it is said in the legal literature, which makes AI unlike other technologies which went before, and practically we can say that AI has a mind of its own, constituting a meta technology. It can be used in almost any domain of industry, commerce, and services, and this characteristic makes the AI more and more widespread, further increasing the magnitude of the potential damages caused by AI. The picture is further complicated by the development methods of AI public institutions involved, private investors involved. Even we can say that AI systems can be developed at fixed location or moving, such self-driving cars or automated boats. We have already robotical surgical instruments operated by AI, all with several manufacturers, and the overall image of responsibility, it's really complicated. To all these factors, also the opacity of functioning of the AI must be added. We don't really know in many of the cases why the AI comes to a certain result or not. So in having in mind this perspective, creating liability rules for AI is not an easy task. And if we are looking for a historical precedent, we can find actually only one during the Industrial Revolution. A huge change was made in the civil law liability rules. Practically, the strict liability was introduced, and this strict and objective liability was a response to the new threats posed by the machines and the new environment created by the Industrial Revolution. And this precedent is, however, imperfect for the AI, as strict liability practically can discourage innovation, and a lot of researchers, including the drafters of the Artificial Intelligence Act, practically said and are presuming at least that AI system will be much more predictable in the future than they are now, warranting actually some form of fault-based liability, practically going back in the pre-industrial revolution era of liability at the present. And having in mind all these, some have proposed that AI system should have legal personality, and this is a solution to the liability gaps which exist for sure. And liability gaps are situations where the presence of an AI system in the scenario must often involving liability for a delict, where damage caused makes proving causation or determining the liable person very difficult or even impossible. So this is a liability gap, and such situations already were faced by legal practice and by the legal literature. For example, in the cases when a bank used a third-party AI system to rate creditworthiness of a person, and after an analysis of the data provided by the AI, it came out that the system discriminated against women. This is also already an example which was raised today. Self-driving car crashes without the fault of the driver. And this is also actually a liability gap in the present. So the existence of liability gaps is not a best state of art today, because actually discourages AI development in two ways. It leads to avoidance of AI technologies if potential users believe that the manufacturers or marketers of the AI will escape liability. And for example, driving an autonomous car, it's a question that if the driver knows that the manufacturer of the AI won't be liable, and he will be liable, so this is a question of am I wanting to use autonomously driving car or not? But also the uncertainty arises in the case of the manufacturers, because they do not know when and for what they are liable. Thereby, this is somehow hindering the appetite to invest into AI development. And the third question, should these liability gaps be breached with AI legal personality? And of course, this is in theory an easy answer and practically would resolve the issues posed by the liability gaps. However, I have found in the course of my research that endowing AI with legal personhood would be a non-solution for the liability problems, at least in civil law, for several reasons. Practically, AI, as a proposed technological person, for example, would not display some very important traits that legal persons have. It cannot participate in the economic exchange in its own name, for its own profit, or at its own risk, as there will always be a human being who directs its action, who benefits from its action and profits practically from the AI. Therefore, the criteria to give legal personality for AI practically is not met. And also, AI would not suffer the consequences of its action in the same way as a human person or a legal person is suffering those consequences today, and that AI may even find those consequences worth of accepting because as a cost of doing business, and because sometimes in the Anglo-Saxon legal literature we can read about the efficient breach of contract. The AI can consider breaking a rule or acting in a certain way this some kind of efficient breach of rules. So there is a moral hazard of creating a legal personality for AI also, and practically it's under discussion what the future of AI is, but for sure, as we see it now, AI cannot benefit from autonomous perception. AI cannot understand the consequences of the behavior as a human being can, and human experience can. Of course, we can add the risk of underfunding electronic persons, which could also lead to limitation of liability, of avoiding altogether liability. And we can conclude that no comprehensive legal doctrine has been yet developed for justifying legal personhood for AI, and the contra-arguments are very strong. So we should look for another solution than giving legal personhood to AI to solve the liability gaps which exist for sure. So the European Union is working hard to find solution, and practically we can say the European Commission correctly recognized the fact that legal personhood is not solution to the existing liability issues. And this recognition of the fact that legal personality is not a solution led to the proposed directive on AI liability. And the problems are with this proposal that practically it is made an option for fault-based liability for the classical delictual liability practically, and when AI damage is concerned. And to make it functional, the system opted for some attenuation of evidentiary requirements for demonstrating non-compliance by the defendant and for the causality between the non-compliance and the damage created. The first presumption is based on the refusal of defendant to provide evidence at the request of the claimant or a potential claimant, and during the litigious case in front of the court. The second presumption results in the case of the so-called high-risk AI from the non-compliance with some precautionary requirements imposed by the Artificial Intelligence Draft Act, and for the non-high-risk AI, this presumption only operates if proof of causality between the non-compliance and the AI output or lack of AI output, particularly the damage, is excessively hard to prove. So we have a fault-based liability for delict in case of, in this proposal, some type of old wine in a new bottle, because this solution practically, as I said before, runs contrary to the great changes in civil liability created by the Industrial Revolution, during which legislators came to favor strict, no-fault objective liability as opposed to fault-based subjective liability in order to combat exactly the liability gaps raised by novel technologies. And practically, due to the Industrial Revolution, we have also the idea of a compulsory insurance system, especially for dangerous industries. And we cannot say that the drafters of the proposed EU legislation did not analyze those solutions, but practically both those solutions, so strict liability and compulsory insurance, at least for certain uses of AI, were practically postponed, deferred in the future as potential future modifications should the AI liability directive requires an update. So practically, as I said, we are in the pre-industrial revolution phase of the development of AI liability. And another issue with the proposed regulation is that this fault model, practically, it seems very centered at the consumer professionist claims when a consumer is raising a claim against a professional. And practically, this is also backed up with a classification of high-risk and non-high-risk AI. This perception is not the best one because professional-to-professional claims can be very easily raised, and the regulation does not focus on it in any way. And also the high-risk and non-high-risk AI dichotomy seems excessive, as the true risk posed by AI maybe is not very evident. So in this phase, which we consider low-risk AI can cause very serious damage, and artificial classification of AI, it seems not precise enough to be at the base of the future regulation. And you can see that I consider that all these arguments favor the strict liability and compulsory insurance model which exists, and which can be a solution for AI posed risks as well. And finally, the regulatory proposals, I just will mention three. In the light of our research and my research especially, AI should not be granted any form of legal personality at this phase of development, because it is just a solution to solve the liability gaps, but in fact leads to more problems than to real solutions, and practically distracts our attention from known and efficient solutions for such cases of liability. The second one, in the line with the evolution of civil liability legislation, in situation when attribution of liability due to fault, existence of the fault, or causation between fault and damaging action or omission is difficult, strict liability opposed to the fault-based liability should be applied. And of course, we can design the circle of humans being responsible for AI. Already there are solutions in this way. And yes, for example, on the question posed by Professor István Ambrus, we can say that yes, the driver is, from civil law perspective, must be held responsible because he is the one who is benefiting from that object which is run by the AI. So we cannot leave the driver outside the scope of civil liability. Of course, we can find another, the programmer and the manufacturer, and also we can open the circle, but the driver is somebody who cannot be left out from this circle of responsibility. And the third issue, high risk as opposed to non-high risk AI, this dichotomy when it comes to liability rules should be practically abandoned, because it does not offer a solution. And in any way, if we come to civil liability, the full compensation of the damage is the rule, even if the AI is of high risk or non-high risk AI. What is the danger? That this EU regulation seems to be a little bit weaker than the legislation which are already in force in some states or under preparation in some states. So this is relatively full with compromises and postponed in the future some basic questions. And practically we should give attention to the future development of this legislation. And of course, if this is the form, present form, will enter into force to seek for further developments and to further modifications, which will be also backed by the practical consequences of the application of this legislation. Thank you very much.
professors. So following the agenda of today's meeting, I would now like to invite you to listen to a presentation entitled Artificial Intelligence, Policing and Criminal Justice, the Lega Ferenda postulates for the Polish and international legislator. Professor Rafał Wielki, who is an assistant professor at the Institute of Legal Studies at the University of Opole, is ready. So, Professor, the floor is yours.
Thank you very much, Professor. Ladies and gentlemen, today I would like to present some elements of my research as well as main conclusions concerning artificial intelligence, policing, and criminal justice, because what's the deal? Legal regulations are still under development following some public consultation. However, we're facing several problems related to the use of artificial intelligence in law enforcement and criminal justice. Main problems are specified in a proposal for a regulation of the European Parliament and the Council laying down harmonized rules on artificial intelligence and amending certain Union legislative acts. It's so-called Artificial Intelligence Act. And the proposals coming out from the European Union are being closely watched by legal scholars from many parts of the world, as the very comprehensive piece of legislation is being drafted to regulate AI in a politically and economically significant region of the world. So, many issues are related to criminal law because the Commission is proposing new rules to make sure that AI systems used in the European Union are safe, transparent, ethical, unbiased, and under human control. And therefore, they are categorized by risks and levels of risks. We will focus only on unacceptable risk and high risk because they are concerning the most problems that criminal law has to deal with. So, if we are talking about unacceptable risk, these are prohibited AI practices. We mean systems that are contrary to the European Union values of respect for human dignity, freedom, equality, democracy, rule of law, fundamental rules of the Union, including also the rights of non-discrimination and the problems of data protection and privacy, also the rights of the children, and posing a clear risk to the security, livelihoods, and rights of citizens. So, what does it mean for criminal law that we have unacceptable risk? That means, according to this draft, that the use of real-time remote biometric identification systems in public spaces for the purpose of law enforcement shall be prohibited. Of course, there are some exceptions, limited exceptions, like the targeted search for victims of crime, including missing children, preventing a specific serious and imminent threat to the life or safety of individuals or a terrorist attack, also detecting, locating, identifying, or prosecuting perpetrators or suspected perpetrators of the most serious crimes, such as, for example, participation in a criminal organization, terrorism, human trafficking, murder, rape, or child pornography. Also, the use of real-time remote biometric identification systems in the public spaces for the purpose of policing shall take into account the following elements. The nature of the situation, giving rise to the possible use, in particular the seriousness, probability, scale, and the harm caused in the absence of the use of the system. Also the consequences of the use of the system for the rights and freedoms of all persons concerned, and each individual use the purpose of law enforcement of a real-time remote biometric identification system in public places shall be subject to a prior authorization granted by some judicial authority or by an independent administrative authority of the member state. However, there is an issue connected to high-risk AI system. As I mentioned before, two levels are the most important: unacceptable risk, that are the prohibited AI practices, AI systems, and high-risk systems. And high-risk systems in policing are, for example, biometric identification and categorization of natural persons. So we have AI systems that intended to be used for real-time or post-remote biometric identification of individuals. Also, we have AI systems intended to be used by law enforcement authorities for making individual risk assessment of a natural person in order to assess the risk for offending in the future. Also, we can say about AI systems that are intended to be used by law enforcement as polygraphs and similar tools to detect emotional state of a natural person, and also systems that are detecting deep fakes for law enforcement authorities. We can also say that high-risk AI systems are systems that are connected to the problem of evaluation of the reliability of evidence. Also, we can say about systems used for crime analysis regarding some natural persons, allowing law enforcement authorities to search complex related and unrelated large data sets available in different data sources and in different data formats to identify unknown patterns or discover hidden relationship in the data. There are also some issues according assessing security or health risk of immigrants using systems to verify the authenticity of travel documents, and researching and interpreting facts and the law. These systems are mentioned to be a high risk systems. But as we can see, the proposals being discussed in the European Union address most of the issues presented as the potential of artificial intelligence in law enforcement, as well as some issues are connected to criminal justice. But the proposals appearing in the project of Act on Artificial Intelligence very carefully addresses the issue of biometric identification and the biometric systems. It's also assumed that the use of AI tools in law enforcement are relatively high risk levels, and they might violate some fundamental rights, maybe also ethically questionable. This shows that while the potential of AI in criminal cases is very high, it requires consideration of all risks and uncertainties. What is interesting, we can also focus on the problem of forecasting of individuals' behavior. This system based on AI is used in the United States. It was called Correctional Offender Management Profiling for Alternative Sanctions. Right now we have the different name is a Northpoint software, and it's used in parole considerations or sentencing decision making. But, however, this system it's used in the US, it's criticized by scientists. Why? Researchers have been critical for such forecasting tools, pointing out that the complex decision boundaries pose serious challenges. To forecast well, a researcher must understand the nature of the complexity, be able to translate that knowledge properly into algebraic expressions, and then have the data to construct an appropriate model. But what's interesting, those algorithms used in recidivism prediction are controversial. Why? Because there was a research that pointed out that it was an experimental study conducted in the United States, and it appears that these tools using AI may be less accurate or less fair than predictions made by people with modest or no experience at all in criminal adjudication. So the views on the issue are disputed, although the current critical of the use of AI in criminological forecasting, because we have the problems with factors that are considered by AI systems. What factors are taken into account? These include property status, place of residence, it's used by zip code, employment, age, gender or race. So predictive systems are said to be based on socioeconomic and demographic criteria, making a priori higher risk in certain subgroups. However, these tools are entering the criminal justice system. They have already been used in some countries in the courtrooms. We have to focus on some legal problems. What should we do? So there are many voices in the discussion about the act on AI. Some voices are strongly supported by NGOs, and there is a great deal of controversy surrounding predictive policing and assignment of this technology to the category of unacceptable risk. It seems that the level of development of AI doesn't have public acceptance right now. This is a proposition to ban the predictive policing at this time. So on the one hand, predictive policing is definitely the next stage of development of police services, law enforcement services, but it has to try to adapt to some social changes. Those systems are used in China, they are used in the United States, but we have to mention that in Europe we have the right to individuals' privacy is a very important value, and those systems can have some problems with those issues. Perhaps, maybe in the future, there will be some change in public feelings about AI, and this will be possible to use it as a system. But right now, in the view of mentioned problems, I think it is necessary to agree with the calls to ban use of predictive policing in European Union. But the second problem is in general, because we know that some exceptions can be made about using artificial intelligence, even if they are in this category of very high level risk. Okay, so we can also focus on biometric identification because it's pretty important in many countries. as we know, it's advocated to prohibit the use of real-time remote biometric systems in public places for law enforcement purposes, and it refers to systems used to identify individuals remotely by comparing their biometric data, like facial image, gait, silhouette outline, with biometric data containing in some references database where data collection, comparison, and identification take place without any significant delay. Of course, in the future, biometric identification will supplant the identification methods used in forensic science, probably, but there is one important condition that must be met. That is validation. Those methods, biometric identification methods, must be validated and be scientifically proven. Right now, we don't have this situation. So validation is the determination of the statistical parameters and some quantitative data. Validation of the methods also allows the recognition of level of error, area of uncertainty that is associated with the use. And as we know, biometric system in European Union and this project is classified as unacceptable risk system, but there are some limited exceptions. Of course, under the proposed amendments, any single use of real-time remote biometric identification system in public places for law enforcement purposes will, as a general rule, require some prior authorization from a court or any independent administrative authority of the member state. But this will be held to any member state. So the member state is obliged to decide on the use of such systems. They will be able to not provide such a possibility or to provide this. In case, as we discussed in our team, in case of Poland and Hungary, we don't know the intentions of legislators, so how they are willing to decide to implement such systems or not. If they decide it will be necessary to regulate this issue in criminal procedure laws in Poland and Hungary, along with the lines of those for some operational control and judicial oversight of investigations. Next problem is the statistical evidence, because this is being an important element of forensic science. Forensic expertise is evolving towards the use of databases on the frequency of occurrence of some characteristics in populations in order to determine the strength of evidence in relation to a particular suspect. And as I mentioned, the methodology of presenting opinion is changing around the world. So there is one change that is positive. It's moving away from a priori assumptions about the uniqueness of certain traits to analyzing and distribution of traits in the populations. But nevertheless, for it to be determined, the strength of evidence according to modern scientific standards, it's necessary to collect databases and to trade it to the population. So this gives opportunity to reconstruct the reasoning, make some own calculations if we use the statistical evidence, but there is a problem because we don't have, especially in Poland, any legal regulations that in criminal procedures that could combat the problem of low quality expert opinions. So this provides a justification to formulate the conclusion that in Poland especially we need an act on experts or so-called witness experts to be drafted urgently. Really, we don't have this act, and because in spite of numerous attempts or over 30 years, I guess, it's not possible to introduce such a regulation to Polish law so far. And this regulation should include an obligation for the expert to make available information about the databases used and the methods used to calculate the strength of evidence and the request of court, at any request of court, prosecution, or defense counsel. And the last thing that I want to mention is connected to forecasting of this criminal behavior. Those activities using AI should be more widely permitted. We can't ignore important issues of public safety as well as matters related to the presentation of evidence in court, but the research shows that AI should not be used in courts to predict future criminal behavior, as today's developing technologies still make mistakes. Moreover, it still raises too many ethical questions that are pretty important. So therefore, we should propose that predictive algorithms should be banned at level of European Union, for example, in cases of parole consideration and or in deciding in sentencing. For right now, maybe in next 10, 20 years, this will be possible when the systems will be much better than today. So, however, the use of such algorithms were to be allowed in the future, the person being analyzed should have access to calculations or source code of this algorithm. Why? Because the individual in criminal case must be able to understand the mechanism of decision making and to learn about the factors that we're taking into account. And this is my point of view about AI and used in law enforcement and criminal justice. Thank you very much for your attention. I'll be more than happy to answer your questions later. Thank you very much.
Thank you very much for your presentation. Following the agenda of today's meeting, I'd like to invite you to listen to the presentation titled Council of Europe Guidelines Concerning Judicial Systems Supported by AI, prepared by Zbigniew Więckowski, who is an assistant professor at the Institute of Legal Studies at the Cardinal Stefan Wyszyński University in Warsaw, the Civil and Private International Law Chair at the Law Faculty. Professor, the floor is yours.
Thank you very much. I'm privileged to have the opportunity to speak in front of you. I'm delighted to have a chance to present some of the findings of my research project conducted within the Polish-Hungarian Research Project 2022. My aim for today is to give you some background about numerous activities undertaken by the Council of Europe, especially by the European Commission for the Efficiency of Justice, called from French SESJA1, in the field of legal aspects of AI, of course. I strongly believe that at the end of my speech, we will be able to agree that the Council of Europe has the significant potential to be the role-playing international organization in terms of setting standards for the judicial systems supported by AI. I plan to be brief, about 15 minutes, I guess, will be enough. Let me start with just a few words about the Council of Europe. I guess that for most of you, it will be just a short reminder. The Council of Europe is the continent's oldest political organization, founded in 1949. For today, it consists of 46 member states with a population of over 650 million in total. In March this year, one country was excluded from this organization, and the Council of Europe was set up to promote democracy and to protect human rights and the rule of law in Europe. The Council of Europe takes up the current issues. The newest example of this is the facial recognition issue. The Council of Europe calls for strict rules for facial recognition activities to avoid the significant risks to privacy. The Council of Europe has proposed some fundamental principles. The first one, use of biometric techniques by the public authorities should be legitimized under clear legislative framework. The second, the legitimate aim should be based on such values as national security, public safety, or the economic well-being of the country. The third, legislation should ensure effective scrutiny over the applied measures based on biometric techniques. The Council of Europe has been shaping the human rights protection system for almost 7 decades. Although it's a regional organization, it often inspires global initiatives. In the case of the ongoing next industrial revolution, artificial intelligence revolution, the Council of Europe supported the vision of a human-centered artificial intelligence system based on human rights. Recent developments in digital justice appear as real opportunities for everybody. Firstly, to improve the quality and the efficiency of justice. Secondly, they constitute new challenges for the respect of the fundamental principles of the trial, essential guarantees of our judicial systems, such as the primacy of the rule of law, the independence and impartiality of the judge, the principle of the adversarial proceedings, or the protection of the fundamental freedoms. In terms of activity relating strictly to the administration of justice, it is important to note the initiatives especially undertaken by the European Commission for the efficiency of justice, as I said before, called from French SESJA1. The SESJA1 was established on September 2002 by the resolution of the Committees of Ministers of the Council of Europe. And what is important to mention is that the SESJA1 task is primarily to collect and analyze data, develop benchmarks, draft reports, guidelines, action plans, and develop, of course, contacts with external stakeholders, especially developers of the IT systems. One of the SESJA1's important tasks is to conduct research on improving the efficiency of the judiciary through the use of information technology solutions. The SESJA1's output to date is really impressive. Just mention a few of them. The first one, from my perspective, the most important, the European Ethical Charter on the use of artificial intelligence in judicial systems and their environment, feasibility study, guidelines, and the last initiative, the revised roadmap for ensuring an appropriate follow-up of the SESJA1 Ethical Charter. The European Ethical Charter on the use of artificial intelligence was the first European text setting out ethical principles relating to the use of artificial intelligence in judicial systems ever. The Charter provides a framework of principles that can guide policymakers, legislators, and justice professionals when they grapple with the rapid development of AI in national judicial processes. And Please take a look at those 5 principles of the ethical charter. The first one, the respect for fundamental rights. The second, non-discrimination. The third, quality and security. The fourth, transparency, impartiality, and fairness. And the last one, under user control. The SESJA Charter represents the first step in the SESJA efforts to promote responsible use of AI in European judicial systems, in accordance, of course, with the Council of Europe's values, especially human rights values. The Charter had the merit of being the first reference document to lay down the main principles to be observed when developing AI applications in a manner that complies with human rights. Developers and users of AI applications, for sure, would benefit from more practical guidance on how to apply those 5 principles laid down in the SESJA Charter. So it is very important to prepare some kind of guidelines for developers and users and to do something which we can call operationalization. 3 years ago, the SESJA decided to establish a new working group on cyber justice and artificial intelligence. The SESJA entrusted the group with the task of developing solutions for the application of artificial intelligence mechanisms and other digital solutions in the justice systems. The group's work should be carried out in coordination with other bodies. The latest SESJA initiative is the Artificial Advisory Board on Artificial Intelligence. Among the members of the quite elite advisory board is a Pole, Professor Marek Świerczyński from Cardinal Wyszyński University in Warsaw. The task of the Artificial Intelligence Advisory Board will be to support the SESJA on issues related to artificial intelligence in the administration of justice. The first task of the advisory board is to advise on the final shape on the new structure that is going to start its duty soon. Is the Resource Center on Cyber Justice and Artificial Intelligence. The goal of the Resource Center will be to provide a thorough and comprehensive review of AI applications currently used in the adjudication process. So the work of SESJA we can conclude it on AI as 3 pillars. So the work of SESJA on AI is based on 3 pillars. The first one are AI standards, the second, tools for courts, and the third, permanent watch. The SESJA, as I said before, is actually developing the new initiative, which is a resource center on cyber justice and artificial intelligence. The resource center will be publicly accessible and it will be, I believe, fruitful source of information. The resource center will become the first address for all professionals wishing to search, share, and discuss relevant information concerning the digital transformation of the judiciary and artificial intelligence. During the 37th SESJA plenary meeting, the action plan for 2022-2025 was adopted. And according to the action plan, to accompany the ongoing digitalization of judicial system, the SESJA should take into account the following orientations. The third one, the efficiency of justice. The transition from paper to digital courts is ongoing and necessary. The second, transparency of justice. New technologies must provide users with better knowledge of procedures, judicial institutions, and the respective roles of each of justice professionals. The third, collaborative justice. All justice professionals contribute to the same public service, so they must cooperate, and their service needs to be easy to use, compatible, and they need to use effective communication tools. Human justice. The judge must remain at the center of the procedure. The fifth, people-centered justice. The training of justice professionals, including lawyers, in the process of digital transformation is vital. The sixth, informed justice. SESJA1 should provide more analyzed information and respond to other requests. And the last one, responsible and reactive SESJA1. Increased application of the European Ethical Charter requires targeted awareness and requires training activities. The target group of the trainings should be, of course, developers of IT tools, potential users of the applications like judges, like prosecutors, like lawyers, but also persons responsible for compulsory certification, allowing them to better understand and consider fundamental rights aspects. The initiatives taken by national governments and international organizations, including the Council of Europe, towards organizing the development of AI are, from my and our team perspective, are more than necessary. It should be considered particularly essential that the digital revolution does not lead to the erosion of human rights. The development of a human-centric vision of AI should be pursued. One of the fundamental rights is access to justice. AI may, on the one hand, vastly enhance access. On the other, it may lead to unfair judgments made by algorithms. Therefore, any legislative initiatives, both at the national or international levels, should focus on how AI can be helpful in facilitating access to justice. The work of the Council of Europe seems to be moving in the right direction. In the first stage, the specialized bodies of the Council of Europe published, as you see on one of the slides, published guidelines which belong to the soft law domain. Currently, an international convention is being developed that will be open not exclusively to member states. Poland and Hungary should support the process of passing such convention and encourage other countries to join. Solely in a case of domination of human-centric vision of AI, based on the well-established standards of the Council of Europe, citizens' right to a fair trial will not only be safe from any potential threats, but due to the AI capabilities, even strengthened. Thank you.
Thank you very much for your presentation. We have one more speaker in this session. So for the next presentation entitled Decision Preparation or Decision Making, the role of artificial intelligence in public administration, I wish to invite Professor Barnabas Hayas. Barnabas Hayas is an associate professor at the Constitutional Law Department of Pazmany Peter Catholic University at the Faculty of Law and Political Science and a judge at the Supreme Court of Hungary. Due to the health issues, Professor Barnabas Hayas will be connecting with us online. So I would like to check if the connection is ready.
Dear colleagues, this research has reminded me of the need of to always go back to basics and to need to adapt everything, especially our own hypothesis. I also found it very difficult that the other members of our research team were giving presentation on more and more exciting topics: self-driving cars, artificial intelligence in criminal proceedings, cybercrime, deepfakes, game cheats, etc. And I would come to along and ruin the mood with my ruminations on administrative law. And as the project draws to a close, I increasingly see that I should have spent more time on the administrative basics, which are deadly dull for the layman. In order to make the legal referenda proposals, one must first be aware the problem to be regulated. But at the same time, the right to good administration and the right to fair trial cannot be ignored for a moment. The right to good administration or administrative due process should be understood as a set of administrative principles which set out certain requirements in relation to procedural law rather than substantive law, and ensure not only the executive acts in accordance with the law, but also it acts in the predictable, efficient and fair manner. Such requirements include, in particular, the rights to be heard, a reasonable period of time, the obligation to state reasons, and a legally limited margin of appreciation. The official activity of the public administration serves the enforcement of the public interest protected by law, the protection of the rights and legitimate interest of the community, the protection of the public order and public safety, the protection of the life, physical integrity, safety and rights of individuals. In the event of decision being contrary to the law, not only the rights of the client or the right of the parties entitled to apply for legal redress may be affected, but also the public interest protected by law. A decision that favorable to the party, but in breach of the law, may harm the public interest and rights in the legitimate interest of others protected by administrative law. With regard to decision taken in the course of the application of administrative law, the institutional system of procedural law must ensure that both requirements deriving from the rule of law, one is the legality of administrative decisions and the requirement of the legal certainty, are satisfied. I invite you to play a game. Imagine that you work in the Ministry of responsible for the administrative procedural law in a European country. In some countries, it is the Ministry of Interior, others the Ministry of Justice, and some others the Ministry of Administration. One afternoon, we are greeted by our boss, who tell us that the government wants to use artificial intelligence in public administration, and that we should prepare the necessary legislation. We know that is an imaginary situation because he also says that money doesn't matter, is not an issue in this situation. In such cases, we first give the e-government lessons that the large amount of cases, which are often easy to decide, well standardized processes based on legislation, justify further development of possibilities of e-government. Perhaps we can also think about millions of man-hours of national economy that could be saved by reducing the time spent on the administrative procedures, and even the reducing of the number of staff in public administration. It is a clear win-win situation. Modern technologies, better public administration, cheaper government. We will carefully consider which is the various AI tools can be or are being used in the public administration, and take a look at the e-government legislation we have. If we are in Hungary, let's say, we can have a very easy answer. The rules on automated decision making have been in force since 2018. They need to be tweaked, tailored bit. It is really simple? No, I am not sure. So let's go step by step. The first problem we face that artificial intelligence is a rather heterogeneous concept, and its meaning has changed from time to time. In order to do our job, I would much more useful to talk about AI tools and to review where and how they are typically used in public administration, and to what extent they have procedural relevance. This is where the first surprise will come. Significant number of AI tools can use without further ado, even in addition to existing legislation. There is no need to regulate the use of so-called administrative Siri and Alexa, so-called virtual agents, but their use can lead to huge increase of efficiency. The number of interaction with other public authorities can be significantly reduced. Information is not tied to office hours, etc. Virtual assistants essentially provide information, and those make it easier for citizens to manage their cases, their affairs. An agent can also assist in filling the forms. There are also virtual assistants who, if they don't know the answer, ask for a human help to answer the question or delegate the process to a human operator. Importantly, these tools do not make decisions, nor do they directly support the authorities' decisions making. Some predictive analytic systems are already part of our daily lives, or have become part of our life in the next years. For example, meteorological, hydrological, agricultural forecasting, COVID contact tracing, etc. Often we do not even notice them. For example, as Rafael mentioned, predictive policing, crime risk prediction, or well-known fraud detection systems. These tools support the initiation of the administrative procedures, but do not make decisions. It may be necessary to regulate the use of these tools to ensure that fundamental procedural rights and non-discriminations are respected. Yes, identity analytics also can be combined with big data, may include deep learning and machine learning systems. In many countries are so central identification agents. The e-administration services can be accessed via this tool. even after face recognition or voice recognition systems, but government's use of identification systems based on biometric data is more typical for law enforcement agencies. AI-based process automation systems can be very diverse, from fully automated decision-making systems to decision support systems to systems for drafting citizens, for example, tax statements. They can also be based on wide range of technologies, from deep learning, machine learning, etc. I think these are the most interesting and most relevant tools for administrative procedural law. Okay, then we know what we are shooting at. AI-based process automation system should be subject to regulatory environment that meets the expectations of the right to good administration, the transparent and otherwise fair, and is accepted by citizens. A bank or any market player could implement any AI-based, fully automated decision-making systems that make certain decisions without any human intervention. In this context, I use the AI-based, fully automated decision-making in that sense that AI does it on its own behalf, under its own authority or our own competency. However, if the administration wants to entrust fully automated decision making to AI, we suddenly find ourselves in a forest of questions where every question answered creates at least two more. I know, yes, I know the codifier does not always deal with some theoretical questions, but this is a hypothetical situation. Let's accept that for now. So there are some authors who says that if an AI tool is capable of substantive case management depends on its ability to provide justification for the decision. I do not think the issue can be simplified that much. On the one hand, there is some acts that do not require any justification. For example, issuing an identity card or a passport. On the other hand, there are questions beyond the existence of justification that we should be able to answer. One of the starting points of our current thinking on administrative law is the concept of administrative act. An administrative act is a declaration of intent or any action by administrative legal entity in the exercise of statutory functions, in the exercise of public authority, which is characterized by the fact that is intent to change the legal situation of addressee of the act, and that there is causal link between the act and the legal effect. However, the person exercising jurisdiction in a specific case is traditionally a specific natural person or a body. The person who has taken the decision, whose name and signature are on the document. This is significant because it leads to a very important question of constitutionality, namely democratic legitimacy. And democratic legitimacy describes the relationship between the source of power and exercisers of power. For example, the community of voters and the executive exercise of powers. We teach from constitutional law that there must be a direct and unbroken chain between the source of power and the exerciser of power. Every act of public authority, from a simple police action to the most complex official case, the decision that determines the life of the country must be traceable to democratic elections. To put it simply, there can be no official power without democratic legitimacy. This is one of the guarantees of the accountability of public authority, public power. It may be asked whether the exercise of power can be artificial intelligence itself. Within the theoretical framework that informs our thinking about the exercise of public power, I would answer definitely no. I think that is as long as we think about competence, public authority, democratic legitimacy, accountability within the existing framework, we cannot come to the conclusions that artificial intelligence can be an exerciser of competence itself. Only if the power exercised by a natural person or body can the chain of democratic legitimacy and the accountability of the decision maker ensured. This does not necessarily preclude solutions where the decision is taken by AI instead of or in behalf of particular person, for example, police captain, head of office or authority. But AI will not be the one exercising the power. In this case, the right to good administration, the regulatory of the procedure is not the responsibility of the AI nor of the creator of the algorithm, but the holder of the power. In such cases, an appropriate mechanism of control within the administration can be established by creating procedural rules that ensure that the decision can be overruled by a living human, often request, of course. This solution is very practical because, in addition to meeting the requirement of democratic legitimacy, it obviates the need to answer questions about the legal personality and liability or responsibility of the AI, and also obviates the need to answer the delicate questions about whether the computer algorithm that makes the decision in the case of AI is or can be subject to judicial review. It is not disputed that, as a general rule, administrative decisions not only have an operative part, but also a justification or statement of reasons, which is indispensable in judicial review. Without this, the administrative courts would not be able to fulfill their function, which is not only to provide legal redress, but also the protect the rights of the public administrations against unlawful acts. Although the so-called expert system can or may be capable of the making decision according to given set of parameters, I do not see any way on the basis of what has been said so far that they can exercise decision-making powers independently. Actions that do not have a direct legal effect on the administrated are not considered to be administrative acts. These non-acts are, for example, actions of control, actions of information, or perhaps the most important is the decision preparation activities for our subject. I believe that in the field of non-acts, these AI tools not only have a role to play, but will become necessary in the near future, or some areas already are. In this context, is worth pointing out that since administrative law does not regulate all aspects of the decision preparation processes, it follows that the governance of public administration has a great deal of freedom in the means and extent to which they support decision preparation, decision support, information, and monitoring also. It would therefore not require legal regulation for the public administration to use decision support, decision preparation tools that really rely on textual analysis of draft decisions to indicate possible errors, as in Social Security Administration in the US have. As much as I had concerns about autonomous decision-making of AI tools, I have known about their use in decision support. Apart from information security and data protection issues, there is no legal reason against the use of these tools in decision making. On the contrary, there are arguments in favor of predictable practice, quality assurance, improving timeliness, and increasing efficiency. Now, back to the questions I asked at the beginning of my presentation. Would it really be enough to find the fine-tune or tailoring the rules in automatic decision making? In the light of above, I think the revision of procedural law is not even necessary element of the widespread use of AI tools in public administration, as long as I itself is not empowered to exercise its powers. Of course, this does not mean that the lege ferenda proposals cannot made in this era. I have a few of myself. First is in all automated decision, not only the decision made with the assistance of AI, it should be possible for dissatisfied party to refer the matter of the living human operator. As I mentioned, this is the case in Hungarian legislation, but such a solution is also known in Norway. There is no reasons to limit the possibility of automated decision making to non-discretionary matters. Automated decisions must also comply with the formal and substantive requirements for administrative decisions. For example, they must include a statement of reasons or justification. It should be ensured that the artificial intelligence tools used in the information monitoring, decision preparation, decision support process are impartial, non-discriminatory, and can be subject to the meaningful verification, and minimum guarantees should be laid down in legislation. I heard a Chinese saying a few years ago, as long as you are hungry, I can't be right. Before lunch, in view of the fact that we are running later than planned, I would like to thank you for your kind attention, and I will try to answer any questions you may have. Thank you.
Thank you very much, Professor. Because I stand between you and the lunch break, and due to the delay in this session, I suggest we move the discussion to a lunch break. But if you have any question to Professor Barnabas Hayas, don't hesitate to ask now. Are there any questions to Professor Barnabas Hayas, who will not join the lunch with us because he's online? Okay, I don't see none. So, I warmly invite you to our next seminar, which will be held on the 6th of December and will focus on artificial intelligence and decision making. And now, thanking you for your kind attention and I wish you a good dinner and fruitful discussions behind the scenes. So thank you very much and have a nice lunch break.